Hello, this is Larry Parman. Sitting with me again today is Jerry Stiles. We are with the firm of Parman and Easterday. We're an estate planning firm located in Oklahoma City and Kansas City. And in these short vignettes, we cover different estate planning topics that we'd like to share with you. And today we're going to talk about one that comes up all the time, which is the different estate planning options that people have out there. So let's just kind of start out and share with folks who are listening what their estate planning options are.
Okay. Well, I think the first misconception that people have is when they think about estate planning, all they think about is what happens when I die and who gets my money. And there are so many more issues that need to be addressed than that, but we'll touch about them in a minute. The first thing that we see far too many people do is nothing. If you do nothing, you leave yourself vulnerable to the state and you leave yourself vulnerable to confusion. What many people consider an estate plan is a will, and they'll put a simple will together, what an I love me, I love you type will that says at my death everything goes to my wife, and at my wife's death it goes to my children. But it doesn't address some of the other hard issues that we'll be talking about later.
You know, one of the options that I hear people talk about all the time, and I know you've seen this too, is the use of joint tenancy. Because they think that through joint tenancy they can accomplish all the objectives that they want to accomplish. And somewhere along the line, people have grown to understand that if two people own their property jointly, when the first person dies, there's no probate. And the reason for that is because that property transfers to the survivor by operation of law. There's no, other than an affidavit of surviving joint tenancy or joint tenant on a piece of property, that's about all that's required. So it ends up being a little bit of a trap, because even though there's no probate at the first death, and that's because the rule is that only property that's individually titled or owned with one person's name on it has to go through probate, they think then that if they avoid probate on the first death, that perhaps they can the second time as well.
Right.
But in fact, what happens is once the first joint tenant dies and there's only one person left, therefore that property is subject to probate.
Exactly.
And then the other thing that I've seen happen so many times, we've talked about this, is that if a husband and wife own property jointly, then the first spouse dies. The second spouse then may think they can continue the joint tenancy by adding children's names to that property.
Right.
You want to share a few things that can happen there?
Yeah, that is a disaster waiting to happen.
Indeed.
And when we see that all the time. What happens if your son's wife files for divorce? All of a sudden that joint tenancy property can be tied up in the courts. What if that son dies? What if he gets sued? So, I mean, more negative things than positive things can happen, and unfortunately in our practice, we see the negative things far more often than we see the positive things.
I think it's important for listeners to know that once you start adding children's names to your property, they are a legal owner of that property. And on real estate, at least in Oklahoma, if that child's married, that child's spouse, your in-law, has a marital interest in that property as well.
That's right.
So as a harsh, stark example, if you wanted to sell your real estate that had your son's name on it, not only would you have to sign off on it, your son would have to sign off on it, and your daughter-in-law would have to sign off on
Correct.
it, right? So like Jerry mentioned, you have asset issues, asset lawsuit issues, you have tax issues that we didn't talk about. It's probably beyond the scope of this video here today. But the point is, the joint tenancy is just not a good option, and you should look beyond it.
Exactly.
The other option that people should consider is a revocable living trust, but we're going to talk about that in another session when we come back. So we're going to sign off right now. Again, this is Larry Parman, along with Jerry Stiles. Our phone number is 405-843-6100. Call us if you have any questions. We'll talk to you later.